Good evening. This is Chris Brill, and with co-chair Frank Sullivan and I, we're here on behalf of the Bucks County Bar Association Judicial Merit Selection Committee. We want to welcome all of you who decided to join us as members of the bar, members of the public, members of the media, and most importantly, our two judicial candidates who are here before you tonight, Tiffany Thomas-Smith and Steve Corr, here to meet the candidate night. Let me just give you a brief background as to why we're here. As many of you know, Judge Rubenstein will be reaching mandatory retirement this year, which will create an opening on our bench. And as a result of that, there'll be an election for a new judge. We have Tiffany and we have Steve here who are declared candidates for that job, and they've decided to participate in the Bar Association's merit selection process. Our merit selection process, which we employ whenever there's a judicial vacancy, consists of the following. First, we ask the candidates to complete a detailed questionnaire, which we then post on our website. Both of these candidates have done that. We also ask the candidates to participate in a meet the candidate night, which is tonight's night, and obviously the two of them are agreeing to do that. Also, we ask the candidates to participate and be part of a plebiscite ballot, which they both agreed to do. There is another candidate running for judge, and that is Amir Stark. Amir has decided not to participate in the plebiscite and not to participate in the questionnaire. Let me tell you what tonight's format is going to be. Each candidate will get 5 minutes for an opening and 5 minutes for a closing and 2 minutes to ask each question. Frank Sullivan and I will take turns asking the questions. And the questions, so you know, are the product of a lot of hard work from members of our Merit Selection Committee, including Maureen Carlton, Elizabeth Feynman, Julie Goldstein, Hillary Noonan, Judith Algio, Georgianne Fusco, and Amy Schneckner, in addition to me and Frank. So we anticipate that the entire event will take approximately 1 hour. And we just want you to know that for the members of the public who are not attorneys, the Bar Association also asks the candidates to participate, as I mentioned, in a plebiscite. The plebiscite, the people voting have 4 options. They can vote as to each candidate, either highly recommended or no opinion or not recommended. So they're the 4 options they have in voting. Now, as I said, we expect this to last about an hour. We're going to move on to closings now, and by openings, yes, it would have been a lot shorter than an hour. So we're going to start with openings, and we're going to start with Steve.
Thanks, Chris. I want to start tonight by thanking Frank and Chris for taking time out of their busy schedules to moderate the forum tonight, and also to Greg and his staff here at the Bar Association for hosting us. I also want to thank Tiffany for participating in this process, because I think this is a very important process for us. I believe that all members of the Bar Association should vet and give their opinion on anybody who intends to run for the Court of Common Pleas. I've been a member of the Bar Association since 1992, and I have participated in every plebiscite that we have held since that time. I believe that plebiscite is an important process because the members of the association are the people in our community who know the abilities of the candidates the best, and they are the best ones to weigh in, to evaluate the candidate's preparedness to become the next judge in the Court of Common Pleas, Bucks County, and then to relay that information out to the public. I'm here tonight to ask for your rating as highly recommended, because I believe I'm the most qualified candidate in this race. Since graduating from Villanova Law School in 1992, my practice has been primarily based here in Bucks County. And while my focus of my practice has been in civil litigation, I practiced in civil, criminal, family, and orphans courts here in Bucks County. I have represented individual clients. I've represented large corporations and small corporations. I've represented both plaintiffs and defendants. I've been involved in individual lawsuits, mass tort litigation, and class actions. My cases have included cases such as landlord-tenant disputes, protection from abuse, motor vehicle accidents, medical malpractice, products liability. I've also represented 26 states in subrogation cases against major oil companies. And 5 minutes. It's 5 minutes. Okay. I've also represented 26 states in subrogation cases against the major oil companies. And I currently serve as a solicitor to the Bensalem Township School District. For the last 20 years, I've had the privilege of representing the victims of the 9/11 attacks in their lawsuit against Iran and those who funded and provided logistical support for those attacks. With approximately 70 jury trials under my belt, I am comfortable in a courtroom. The majority of my jury trials have taken place here in Bucks County, but I've also tried cases in Philadelphia, Montgomery County, Delaware County, and also in New Jersey, Florida, and Ohio. In addition to my jury trials, I've also litigated cases in states throughout the country. That would include California, New York, Louisiana, Georgia, Arkansas. My trials have lasted anywhere from 2 to 3 days, and 6 of them have lasted between 25 and 32 trial days. So to say that I'm familiar with the rules of procedure and the rules of evidence, I think is an understatement. But I say all this because my experience gives me a unique view of how courts are managed throughout this country. And I can bring that unique experience to our bench here in Bucks County. In addition to representing clients in cases, I've also been asked by some of you, the members of the bar, to serve as an arbitrator in cases to help you resolve cases. So I have experience being a neutral and impartial decision maker in cases. And I have ruled on evidentiary issues. I have applied the law to the facts of cases in front of me and made final decisions. In my mass tort work, I've been selected by federal judges to serve as plaintiff's liaison counsel in 4 multi-district litigations. In that role, I served as the liaison between the court and the litigants. And that gives me another unique perspective. I've been able to work with the courts to resolve tens of thousands of cases that way. In my personal life, I've always believed in being an active member of the community. I've served on boards in Warrington Township on 3 different boards. As the father of 3 daughters, I served as a coach for young girls in basketball, volleyball, softball, and hopefully acted as a mentor in those. For years, I've been an extraordinary minister in my church. I visit the sick and homebound of my parish community. And as many of you know, I served 12 years on the Central Bucks School Board. I think that these community involvement help with the overall picture of somebody who wants to serve the community here in Bucks County on the Court of Common Pleas. I also believe that I have the appropriate temperament to be a good judge. I believe attorneys have a duty, just like judges have a duty, to treat everyone with civility. That means every person who comes in contact with the legal system should be treated with dignity and respect. I'm proud of the great relationships I've formed in the Bar Association with judges I've appeared before and with litigants who I've been on the opposite side of. Those are things I carry with me. And while I can't, as a judicial candidate, make certain promises to you, I can make this one promise to you, and that is that I will continue to conduct myself in a civil and dignified manner if I'm elected judge of the Court of Common Pleas. Thank you.
Thanks very much, Steve. All right, Tiffany, you're up.
Thank you. Thank you so much. Thank you, members of the bar. Thank you, Stephen. It's so glad to meet you. I want to thank you all this evening for allowing me to come before you to present myself. My name is Tiffany Thomas-Smith, and I am a family law attorney. I practice here in Bucks County, and I am the owner and operator of the Thomas-Smith firm. I am running for this position in the Court of Common Pleas because I truly believe that the court needs someone with the compassion and integrity and commitment to community that I have. I know many of you from my practice in family law, and I have worked with you also in numerous and various different positions with regard to the bar. Many of you know that I was most recently appointed to the Board of Directors of the Bar Association. that in and of itself is a tremendous honor for me, because not only has it given me the opportunity to serve the community of Bucks County, it's given me the opportunity to work with attorneys in various other aspects of the law, other than family law, other than criminal law, and it's given me a tremendous amount of exposure to the needs of the other members of the bar and other areas of the court. I also have had the opportunity to serve as the chairperson of the Diversity and Inclusion Committee. And in that role, it has been one of the most significant roles that I have served in any organization that I've worked in, because not only have I been able to, again, work with you all, but we've been able to present difficult issues, challenging issues, community issues through our bench and our bar. And we've been able to bring the community into these different CLEs and events that we've had. And they've literally been groundbreaking and they've been record breaking in terms of attendance, because there's a need. There's a need in Bucks County that has not yet been met. And that's a need for a judge who has the type of commitment to community that I have. If I'm serving, will serve with what I call compassionate justice, which is intellect and integrity, applying the facts and the law to the specific people that appear before us. The pandemic has caused a tremendous amount of disruption in all of our lives, but particularly in our courts, as it's impacted families and as it's impacted businesses. And for the most part, those are the people that we deal with on a daily basis in our practices. So we need a judge who's not only familiar with the practice and familiar with the law and willing to operate with compassion and willing to operate with integrity, but also who has the technological savvy to be able to move the cases forward. Our judges on the bench have done a great job. Our court staff has done a phenomenal job, but the problem still exists. So the next judge that takes the bench will be faced with some challenges that have never been challenges before, and I'm prepared to meet those challenges. Additionally, as I mentioned, I have tremendous amount of community service. I'm a breast cancer survivor, I'm a mom, and I'm an attorney that runs her own practice. And in those experiences, I have achieved certain levels of success by recognizing those who have helped and supported me and by how they've helped and supported me. So most of that is related to community service. I served on the board of directors of the Healing Consciousness Foundation, who works with breast cancer survivors. I've also worked with the United Way, and I'm proud to say, as a member of the board of the United Way, I have been out there working with families and working with children and working with board members to address issues like the food shortage and homelessness and the other issues that are pervasive in Bucks County. Sometimes as attorneys, we don't necessarily see that. So as a judge on the bench, I'm going to bring my experience, I'm going to bring my integrity, and I'm also going to bring my relationship with the community to the bench to best serve you, as well as best serve the members of our community. I believe in my 20 years of experience, I have the opportunity to do that in a way that's going to be effective, in a way that's going to be different, and frankly, in a way that, as I mentioned, is going to be compassionate, such that I'm able to serve the needs of the members of the bench and the bar and the community on day one, because as a family attorney, I practice not only in PFA court and in support court, and most of my cases, if you review the docket, my parents have been injured in family law cases, and it establishes that I'm the best candidate to serve in that position. So I ask for your high ratings. I ask for your attention this evening with Stephen and I appreciate your time. Thank you.
Thank you very much, Tiffany, and thank you, Steve, by the agreement prior to our presentation this evening. You get the first question. So the first question is, of all the qualities and characteristics that makes a person a good judge, which ones do you believe you most possess, and which one do you least?
So I believe that a judge, the key trait for a judge is character. And I think character is made up of several things. One, Tiffany mentioned integrity. What do you believe in, and do you stand by your beliefs? And I think that a judge has to do that. If you look at my experience throughout the work I've done in the court system and in the community, I've always stood up for my own beliefs and pushed forward and done things. You could ask the people that I served on the school board with. I was frequently heard to say in meetings, we have to do the right thing. It doesn't matter what pressures we're receiving from outside. We have to do the right thing. And I think that goes to a person's character. A person's experience goes into their character. What have they done in their professional life? What have they done in their personal life? And how have they carried that forward to others? I think I've tried to share whatever talents I have with the community at large, whether it is the Bar Association. I also served on the board of directors, I think, under Frank Sullivan's tenure. But I've served here, and I've tried to serve in my community, whether it's my church, my township, or my school district. And then I think that the overall presence of civility, and I think that is how do we treat people. And I've always lived by the golden rule, treat people the way you want to be treated. And I think that we have to treat people with dignity and the respect that they all deserve, and in particular when they come into the court system when they're at their most stressful time of their life.
Tiffany, same question. Of all the qualities and characteristics that make a person a judge, which one do you believe you most possess and least possess?
Well, I believe that the characteristics that immediately pop out for me are integrity, morality, intelligence, and knowledge of the rule of law. And in terms of integrity and morality, I think that those are my strengths. I think that I operate not only in the resolution of matters for my clients with integrity, but also how I interact with my fellow colleagues. It's an integral part of how I function as an attorney. And morality, I think, also supersedes that. Whatever we do, whenever we do it, once we wake up and we put our feet on the ground when we wake up in the morning, should be something that we do with this elevated sense of morality when we're doing it. Not in judgment, but in morality. Where I struggle is because I haven't practiced, and I don't know any of us at all that have practiced in every aspect of the area of the law, is perhaps in the analysis of the rule of law in areas where I haven't practiced. And I think that that would be my biggest challenge. But it's a challenge that I would wholeheartedly accept and take on to put in the time and the energy and the study that it would take, that would be required to be the best judge on the bench for the people of Bucks County.
Thank you.
Tiffany, as you know, the format for tonight's question and answering session is we're going to alternate between candidates. So because Steve had the first opportunity for the last question, now you have the first opportunity for the next question. And Frank and I will alternate giving the questions. So the question we ask now of you is this: what would be the most effective method you would suggest for improving court procedures and increasing efficiency?
Well, I spoke to that in my opening because I think that's one of the biggest issues that we're all facing. We're facing what I call the crisis. Maybe it's no longer a crisis, but it's more the lingering effects of what's happened since the COVID shutdown. And that's just exacerbated what has been an already existing challenge to scheduling and to having the time in an 8+ hour day to meet the needs of the people of Bucks County who are appearing before us. So whether it be in a criminal case, whether it be in a family law case, whether it be in a civil matter, a jury trial, time is sometimes our enemy. And since we've been impacted in a negative way by COVID, these cases are in fact, unfortunately, backlogged. So people's needs aren't being met, particularly in the realm of the criminal law, because people are being incarcerated longer than their sentences would be potentially if they were found guilty. That's something that we need to remedy. So how would we remedy that? Well, we're already doing it in part. We're doing a lot of Zoom hearings. We're doing other virtual proceedings. I think we can continue to do more, and I think we can incorporate that type of technology and virtual proceedings in our day-to-day operation so that we operate far more efficiently to get the cases not only recognized and handled, but to get them handled in a way that not only suits the attorneys, those of us who are trying to make a living every single day, but also suits the needs of our clients. I think efficiency through technology is something that is doable. We're doing it, and we can continue to do that.
Steve, same question, let me repeat it. What would be the most effective method you would suggest for improving court procedures and increasing efficiency?
I would suggest that it's technology, and I'm the candidate who has that experience. For probably 10 years, I was the chairman of the technology committee of the Bar Association. I was instrumental in working with the Pathonetary's office to bring e-filing here to Bucks County. I think that when we see what happened with the pandemic, the court started to use technology more and more, and I believe that we should continue to use that into the future. And we can take examples of people who don't have access to the court. Sometimes at PFA courts, people struggle to get transportation or to find childcare. We should be able to find a way, especially in those cases that are unopposed, we should find a way to have those people appear by video conference. We're using video conference through Zoom or Microsoft Teams. As long as we can do it in a way that is protected, that people's privacy rights are protected, I think that it deserves exploration. In my work here with the Bar Association and bringing technology to the county, on the one hand with e-filing, I'm in a great position to do those explorations. And I have a lot of experience working in my firm, as the head of our technology committee, and in the past with other firms that I've been with, being the head of technology in those firms as well. So technology is really where we can bring efficiency. It can be in pre-trial conferences where, we have attorneys driving half an hour or 45 minutes from one end of the county to come to the courthouse for a 10-minute conference. We could do that by Zoom or by video conference. And same thing, I think, with out-of-state witnesses. We have litigants who are spending a lot of money on out-of-state witnesses, and we could have them just come in through video conference, testify. They're able to be cross-examined and testify on direct examination without problem. We should be able to do that. And with our technologies today, we can share exhibits and everything else.
Steve, you'll go next first on the next question that Frank's going to ask you.
Okay. Steve, what do you perceive to be the greatest obstacle, if any, for equal justice for all?
I think that some of it is the perception, or not the perception, but the conduct of jurists as they treat people coming into the system. People are coming into the system, and as I said earlier, it's the most stressful time of their life. Whether it's a civil case, criminal case, or a family law case, they're at their peak of their stress in their life. They're in a system that's foreign to them. And I think it takes a lot for a judge to, as I said before, to treat the people with dignity and respect that they deserve, to calm their nerves, to bring them in. And I think that using technologies that we've talked about also is a good way to bring people into the system and to process them quicker. I mean, one of the problems I see, I work with the lawyers in my office who are family law specialists, and I see these cases dragging on and on. And you have families that are at their stressful point. They're talking about custody of children or finances, and these cases are dragging on and on. And I think that we need to find a way to consolidate that or to bring it into a tighter time frame so that we process cases faster. As Tiffany mentioned, just with the pandemic, the criminal justice system needs to be addressed. I mean, we need to move cases forward so that these people aren't sitting in prison when they don't deserve to be there, and get them processed and make sure that they have their fair day in court. And really importantly, with civil cases, we have a lot of people who've been, if it's a personal injury case or whatever the civil case is, these cases have not been able to come to a jury trial for more than a year. I mean, these jury trials are backed up and backlogged. That's really the place in the system that's backlogged right now. And we need a judge who can come in and work on day one with a jury trial. And I wouldn't have to have on-the-job training for that. I've done it all myself.
Thank you, Steve. Tiffany, again, What do you perceive to be the greatest obstacle, if any, for equal justice for all?
So I'm going to take a little bit of a different approach, because maybe I heard the question differently. But to me, equal justice for all is beyond the scope of our courts, it's beyond the scope of our bar here. It has to do, in my opinion, with more of some of the things that we've explored through the Diversity and Inclusion Committee and some of my personal experiences. So I would say equal justice for all is going to come out of two things. And one relates directly to us, the voting. Equal justice for all is ensuring that everyone, each and every person who is registered to vote or has the opportunity to vote, has registered to vote, and can express what their desire is in terms of how they want to see policy changes made directly by their incredibly important opportunities that they have. So I think equal justice for all is ensuring that everyone's voting rights are protected. The second piece to this is I think equal justice for all from a policy perspective comes in whether or not we are addressing things that are systemically inappropriate for some or systemically negatively impactful to some. And when we do the analysis of that, we look for creative and not only creative, but impactful ways to address that systemic issue. One example might be, as it was mentioned, that parties in PFA court may not have the finances to get to court. Parties in criminal cases sometimes may not have the finances to get to court. In civil cases, I'm sure that there are issues also that result directly from the negative impact on the case resulting from a social justice issue. So I think it's important to address social justice issues and inequalities in terms of economy, as well as looking at some of the inequalities that are impacting the cases for other reasons. But I think that's our biggest obstacle right now.
Tiffany, you get the first part of the apple on the next question now. And here it is. If you became aware of unethical conduct on the part of a trial advocate in a case where you were presiding, how would you handle it?
I think that it would be important, obviously, to address the issue immediately. So I think as we have the professional rule of conduct that we have to follow, the judicial rule of conduct that we would have to strictly follow. But if that were a situation where I had an opportunity to speak to that attorney, to the litigator, in a way that would present them with an opportunity to try to cure the wrongdoing without negatively impacting their life, their career, possibly what they've built, and to be able to remedy that situation within the confines of the rule of law, that would be my approach. I would first take the approach of speaking to, or I'm going to backtrack for a second. I would first take the approach of consulting with the rules of judicial conduct to find out what the right procedure would be. I would probably then consult with the president judge and advise them of the issue. Then, if it were appropriate pursuant to the rules and pursuant to that guidance, I would get the attention of that attorney and allow them to at least present in a way that within the rule of law remedy whatever conduct, inappropriate conduct that they had.
Thank you. Steve, let me repeat the question and ask you to answer it. If you became aware of unethical conduct on the part of the trial advocate in a case where you were presiding, how would you handle that?
I'm the judge presiding on the case. I have a duty to address it immediately. I would talk to the litigant immediately, the attorney, and bring them into chambers, put a halt to the proceedings. If it was in the middle of the proceedings, if it was some other way that I found out, I would definitely address it directly with the attorney. I also believe that we have an obligation to report that to the board, the disciplinary board. And I think that we have the disciplinary board in place for a reason, and that is so that they can take an investigation and make a ruling on that. So I think that the most important thing is to address it immediately with the attorney who you're saying it was unethical. conduct. I assume it's something that we don't need to look up or ask other people questions about. It's something that I would know right away. It's unethical, some unethical conduct. I would address it with the attorney, report it to the disciplinary board, and let the disciplinary board do its job, because we as lawyers have the disciplinary board to do that job. It's not the job of the presiding judge to do that, but the disciplinary board to take final action.
Thank you, Steve. Steve, as you know, the Bucks County Judiciary has had few women jurists to date and has had no black women jurists. To what extent, if any, should gender or race be a factor in choosing a judge to sit on the Court of Common Pleas of Bucks County?
Well, that's a tough question, I know, but I don't think that gender or race should play a part in any of our decisions of how we treat people. I think that what we should be looking for on the judiciary is people with the experience and the temperament to be good judges. And I don't think that my gender or my race has any impact on what kind of judge I will be. What will make me a good judge is the experience that I have. And I think you can see from my resume that my experience is broad and deep in all, and not all areas of law, but many of the areas of the law that come before the Court of Common Pleas. So while I recognize that we haven't had too many women and we haven't had any black women who were judges in the Court of Common Pleas here in Bucks County, I don't think that that's a consideration for the job. The job is who is the person that is best prepared to be a judge to serve the community as a judge in the Court of Common Pleas.
Tiffany, same question. As you know, the Bucks County Judiciary has had few women jurists to date and has had no black women jurists. To what extent, if any, should gender or race be a factor in choosing a judge to sit on the Court of Common Pleas of Bucks County?
Well, I think that gender and or race shouldn't be a factor in considering whether or not someone has a qualification to sit as a judge anywhere. I know not only in the Court of Common Pleas of Bucks County. I think that obviously the qualifications for being a judge should be absolutely rooted in what those qualifications require, which is moral compass, integrity, intelligence, knowledge of the rule of law, ability to be compassionate and understanding, and all of those factors which are overarching. I think the question may be raised because when there is a lack of diversity in systems, and the court is a system, the bench is a system. When there is diversity, there are studies that have shown that diversity improves the quality of the system, and education improves the quality of the system. Education in the sense of understanding and empathy for others, and that increases what I'm arguing, or what I would say rather, is it increases the depth of the bench, the depth of experiences that like-minded people or men and women who are of the same ilk may not have the opportunity to expand that depth and breadth of experience by not bringing in someone else who is culturally different, who has a different sense of awareness, who has a different sense of experiences. So bringing in racial diversity and gender diversity expands the opportunity for the members of the bench and the bar, and frankly the community, to have more of a deeper understanding of what needs and expectations are and how to do things better. I think it lends itself to.
Tiffany, now you get the first bite of the apple on the next question, and which is this. How do you deal with difficult people, including peers, lawyers, clients, or litigants? Obviously, no one in this room.
I know I'm on the call. Well, and I think it goes without saying, I think I said in the beginning of this, I practice family law. So the challenges of personality types are something that we deal with often, and I consider it just that, the challenge to a personality type. There are people's personalities that can be difficult. That doesn't mean that their needs shouldn't be met and that they shouldn't be heard. So how do I specifically deal with that? I try to meet people where they are. I think that's important for judges on the bench, not to literally meet people where they are because you're not going to come off the bench, but to meet people where they are in terms of understanding where they came from, where they are now before you in any circumstance, and how to reach a resolution of whatever issues that you're there to reach. So for example, for a client, it's trying to meet the clients where they are in terms of their needs and helping them understand what the best resolution is in consideration of the other person's perspective, the other party. As a judge, I think you're going to have circumstances where you might see someone who hasn't followed an order, who's in contempt. The assumption is factually there could be an order and they could be in contempt of that order. But I think it's really important to try to put a pin in it and understand the why. And if there's an explanation as to the why, I think you can again reach better results. So my goal and my practice is to, like I said, try to meet people where they are, understand why they might be of the mindset that they are in that moment, and utilize that to help reach a resolution.
Thank you. Steve, let me ask you the same question. How do you deal with difficult people, including peers, lawyers, clients, or litigants?
So the first step for me is always introspection. When you say people, difficult people, I start from the position of what am I doing? Am I doing something that makes this relationship difficult? And then I try to work from that perspective out. Frequently, the way that I do deal with it is I try not to take anything personally. I know that, especially being in litigation, that tempers run hot sometimes, that people say things that they don't necessarily mean. And I think we just have to take a step back, take a look at the position that they're in. And that is, quite frankly, that's empathy, right? We have to be able to see things from the other's perspective. And I think that starts from the introspection and then to put yourself in the shoes of the person that you have described as difficult. Sometimes we don't mix, we have relationships that maybe are not perfect, but we can work our way through that. And just from a personal standpoint, I mean, serving 12 years on the school board has put me in a lot of jams where people weren't real happy with things that we did. And I used to say to our board, no matter what we do, we're dealing with people's children. And that is when, tempers flare and people's back gets up about something and they'll say things to you, that they don't mean that thing. And they're angry about the situation that you're in. And I think you just have to have a calming presence to have empathy for the person that's there, but more importantly, introspection of what am I doing in this relationship and how can I help this relationship move forward?
Steve, to what extent do you think attorneys should be permitted to handle the questioning of potential jurors in voir dire versus a judge handling the question?
Well, as somebody who has had a lot of jury trials, I've been in front of a lot of juries. I've had jury selections that have lasted a week and a half, and I've had jury selections that have lasted about 10 minutes when a judge does it. So I prefer and to allow attorneys to do their job. They're there for a purpose, and they're there when they're doing jury selection to pick a fair and impartial jury. And I think a judge plays a role in that to make sure that the process is fair. But I think that ultimately, I believe that attorneys should be allowed to question the jurors, to make challenges to jurors, to make sure that they are picking a fair and impartial jury, to give the litigants the, even if, we think that we're always trying to get an advantage as an attorney. Oh, we'll pick this jury. Really, the best juries are the blank slates who are there just to listen to the facts that are there. And I think that when you allow the attorneys to question the jurors, the litigants themselves have a better experience in court. They feel like they are getting a fair hearing. They feel like the system is fair, and that they did have an opportunity to, make sure that the jury was fair. If the attorney's happy with it, then they should be happy with it. When a judge comes in and says, "I got 15 minutes, and we're going to ask these 10 questions, and then we're done picking them. We're out of here by lunch," I don't think that's the right way to go about it. I think you have to take the time to make sure that litigants who are in court are aware of what's going on and get a fair and impartial jury.
Thank you. Tiffany, to what extent do you think attorneys should be permitted to handle the questioning of potential jurors in voir dire versus allowing the judge to handle the question?
Well, I don't have an extensive area in that practice as others, but I think just from the perspective of doing analysis of criminal cases and civil cases, I think it's absolutely appropriate for the attorneys to do the voir dire for a number of reasons. Number one, the attorneys have prepped their cases. They know their cases, and the judge's perspective, I think I would perceive the judge's perspective is to hear the arguments made by counsel. So in a civil case, I think that both civil attorneys should certainly be given the opportunity to utilize their strategy and the tactic and the prep that they've done to select what may be the most integral part of their case, which is their jury. And in criminal cases, I think that it is absolutely crucial for the criminal defense attorney and the DA to have the opportunity, because they know their strategy, to look to the jury to try to select who, maybe it's a blank slate or maybe it's not, depending on their strategy, to give them the opportunity to utilize their skill set, their knowledge, and to try to then use their jury to present to the judge whatever their case is. So I think that, if I were given the opportunity, or if I had, the choice, I would certainly lean towards giving the attorneys the right to do their job and the opportunity to do their job.
Tiffany, you go next. This may be viewed as a kind of a softball question, so here it is. Do you believe that the relationship between the court and the Bar Association is important as you stand here in the Bar Association building? And if so, how would you work to maintain it or improve it?
I'm going to say yes. So the relationship between the bench and the bar is the question?
Yes.
So I think that personally as an attorney, the relationship that
And the Bar Association.
that exists between the Bar Association and the attorneys and the judges is one of the really rare and few opportunities where those entities get to mix and actually get to have true and interesting and fun sometimes, as well as intellectual interactions. Because as attorneys, we're presenting to the judges all of the time. So you don't really necessarily have the feeling that you can approach a judge after you've done a case before them and ask them a question outside of the scope of what that case is related to. The Bar Association is kind of like the central hub of all of that, because it gives us an opportunity, like in a really safe place, and this happens to be a safe, beautiful place, the chance to have real meaningful interactions from different perspectives of just doing our job, socially, intellectually, morally, and otherwise. And as I said, sometimes in more fun ways, to get to know the judges. I think as for me, as I know the judges better, it makes me a better litigator, because I have a deeper understanding of what they're looking for in cases, and that ultimately helps my clients. So I think full circle, it is a softball question because it's an obvious yes, but I think the reasons why are as I outlined is that interaction that this place has been able to create for us.
Steve, same question. Do you believe that the relationship between the court and the Bar Association is important? And if so, how would you work to maintain it or improve it?
So yes, obviously, I think that the relationship between the court and the Bar Association is extremely important. I've been in the Bar Association since, as I said, since 1992. I've had great relationships with the judges because I have interacted with them here in the Bar Association, whether it be at the bench bar conferences or on committees when I'm doing a CLE with a judge. For the past, 7 years or so, I've been in the Inn of Court, so work with judges in the Inn of Court to make presentations and meet with them on both a social and an intellectual level. And I think it's important because we do get to know who each other are. So when we, as I said earlier, empathy is an important aspect for a judge. It's also an important aspect, trait for a lawyer. And I think when we can get a better understanding of who the judges are, what they do, what makes them tick. And the same for them. They understand us on a social level as well as a professional level. I think it just helps with the system, the way the system works. It helps litigants have confidence in the system, that the system is fair and impartial, because a judge can separate themselves from these things, just as we do when we go in front of a judge that, you know, is the head of our intercourts team or something. We can go in front of them and know exactly what they do and how they do it, but also know that they're not going to give preferential treatment to me. And that's the great thing that we have about the bench that we practice in front of here at Bucks County. So I've always maintained good relationships with the bench. I'm personal friends with a lot of the judges today, and those judges are personal friends with a lot of members of our association. And I would continue that by actively participating in CLEs and coming to committee meetings or to division meetings and speaking with the attorneys directly in an atmosphere that's outside of the court.
A little variation on that theme, Steve. Under what circumstances should a judge report an attorney to the disciplinary board to exhibit some type of impairment? And how would you handle a situation where an attorney shows up in court in an impaired state?
Yeah, I think that's obviously a difficult question for where we are, especially in today's environment where we have the spread of opioids and you know, alcoholism and things of that nature that we see. The Bar Association itself has, as we know, lawyers helping lawyers, and I think that that's one vehicle that I would use as a judge. I do think that it depends on the circumstances of when I would report somebody to a disciplinary board. If somebody showed up in an impaired state, I think that my first inclination would be that this person has a problem that needs to be addressed, that I would address it with them personally. I would encourage them to get help through the Bar Association and outside professional. I think that I think that is a sort of a case-by-case basis of whether I would report that to the disciplinary board off the bat, because while they might be in an impaired state, it would depend on whether they have done something that I feel has violated the rules of professional conduct that deserves a report to the disciplinary board. I would think that most situations would require a report such as that, but I also would, I think, stress in that I believe that people deserve second chances. I believe that people can overcome those problems, and that we should do everything we can to help those people overcome those problems.
Tiffany, under what circumstances should a judge report an attorney to the disciplinary board who exhibits some type of impairment? And how would you handle a situation where an attorney showed up in court in an impaired state?
Well, to answer the first part of the question, I think that the referral to lawyers helping lawyers is one of the means that I would utilize, because I think that they possess the area of expertise to address issues of mental health issues, addiction issues, other substance issues, alcohol issues, that may be the root of that challenge for that individual attorney. Differently than the prior question, you know, if the attorney appears before a judge in an impaired state, that is a direct reflection of their ability to represent their client. It's also a directly has an impact on the proceeding, and I think it directly has an impact on their perception of the court and you know, the importance of the court to them. There should be an elevated sense of recognition of the importance of the court if we're going to be serving in the court. So if there were a situation where an attorney literally showed up in an impaired state, I would immediately cease the proceedings and perhaps call that, depending on circumstance, perhaps call that person into chambers and give them the directive that I think that they do need to seek help immediately. But from a procedural perspective, I would also ensure that, you know, upon them, how this is impacting their client and how that is a breach of so many other issues, you know, ethically and otherwise, from a perspective of their ability to continue to practice law. And I would think that that would hit home with them such that they would take the necessary steps to remedy the situation. If not, I possibly would remove them from the case because they're impacting their client in a way that could have negative impacts on an individual that didn't know that they were getting themselves into.
Tiffany, this is the 10th and final question. And so, let me ask it first of you and then it's Steve. Who is the judge that you admire, and for what reason do you admire that judge the most?
So, interestingly enough, there are two judges that I speak to on this issue. And the first is Thomas-Smith. And Thomas-Smith is not my dad. Thomas-Smith is not related to me. Thomas-Smith is the first judge that I clerked for in Mount Holly, New Jersey, when I initially was at the public defender's office in Philadelphia, and then I had an opportunity to clerk for this wonderful, what I'm going to say, called man, who was a gentle giant, and he was sitting on the bench, he was a man of law, and I've expressed to some others, we had one of the most difficult cases it's one of the most difficult cases that I've ever been involved in, and as a young person at the time, I was pregnant with my son, 20 plus years ago, and he had to handle an abuse case, which involved a very young girl and her dad, and multiple cases of abuse. And how he handled that case, when I talk about compassion and justice, that's where that phrase comes from. He handled the case, and he handled the difficulties of it, and he shielded me in many ways from having to deal with the horrific things that were recorded in that situation. And he did it in a way that the results that he had were always focused on helping that child, always focused on getting the best result for that child, and it was difficult. So Thomas-Smith is one of the judges that I admire. Martin Thomas, I mean, obviously. And I also would like to mention that, I think it's obvious to many that I have tremendous respect for the judges on the bench here. For that group of times that Wade has been very, very instrumental in giving me some guidance in terms of how to conduct myself in bar and how to have some fantastic programs. And I appreciate them for that. So I would say also, simply.
Thank you. All right, Steve, final question, final response, but after, although you two are going to follow up with it with closing remarks. But let me repeat the question for you, Steve. Who is the judge that you most admire, and for what reason do you admire that judge?
So this also is fairly easy for me. I'm going to say my uncle, Tom O'Neill, who served for about 30 years on the Eastern District of Pennsylvania. He passed away a couple of years ago, but he was, obviously I never practiced in front of him. I have watched him in court. I've sat in chambers with him many times. He had a reputation as honest as the day is long. And he was sympathetic, empathetic, and compassionate. And I think he was sharp until the day he left the bench. He was well studied, well read, and fair to everybody that came in front of him. And I think that's the kind of jurist I would want to be. And I admire that, and not only that, but also just knowing him personally in his personal life and the way he conducted himself. From a local standpoint, I would say one of the judges I truly admire is Cynthia Root. She obviously spent years here in the Court of Common Pleas and now in the Eastern District. I practiced before her in the Court of Common Pleas and in the Eastern District. And I would say that of all the judges I've been before, she bends over backwards to make sure that everybody has a fair hearing. Everybody gets their say. Everybody comes in and they know when they left that the judge has sat with an open mind, listened to their case, and given a fair ruling. So those are the two judges I can think of.
Okay, at this point now, we're going to have closings, 5-minute closings for each of you, and by agreement, I believe, of the parties.
Or according to us.
Or according to us. All the evidence supports that.
Thank you. Well, again, I want to say thank you to you, Chris, and to you, Frank, and Greg, and Sean, who's here, and to you, Tiffany. Thank you for participating in this forum. I know how important this forum is to us in the Bar Association, and thank you to all of you who have tuned in for yet another Zoom conference. Hopefully, we've been able to provide you with the information you need to make an informed recommendation. In my opening remarks, I talked a lot about my experience and my belief that the depth and breadth of my experience is what we're looking for in the next candidate or the next judge in the Court of Common Pleas. This last year has been very challenging for every individual and every business. The court system is no exception. Bucks County is blessed to be served by excellent jurists on our bench. Through the ongoing judicial emergency, our judges have been able to keep cases moving through the system. But the only thing they've not been able to do is hold jury trials. For more than a year, we have had hardly any jury trials. These cases are backing up, whether they are criminal or civil. The jury trials are backing up, and there's a backlog there. With my experience, I'm confident that I can help relieve that backlog from day one. I won't need on-the-job training. I'll be able to do it from the day I set foot in the courthouse because I've done it all my career. The pandemic has also brought issues such as access to the courts and mental health to the forefront. As the head of the technology committee, I mentioned earlier that I was instrumental in working with the Patentory's office to bring e-filing to Bucks County several years ago. During the pandemic, the courts have been using technology more and more, and I am committed to using it for the benefit of all of our citizens in Bucks County into the future. As I described earlier, there are people who come into the system, but they don't have the ability to get to the courthouse in Doylestown. They don't have the ability to get childcare. They don't have the ability to take a full day off of work for a 30-minute hearing in Doylestown. So I think that for those folks, we have to make it more accessible to them, and we can use technology to do that. We should be using it for other litigants as well. As I mentioned, just out-of-state witnesses, they should be able to come in by video conference. We have no problem doing it today. We can do it, and we do it every day. If we're on Zoom, Teams, whatever our system is, we're able to do it, and we should explore ways to do that to help with the efficiency of the court. I'm excited that Judge Bateman has announced that we'll be starting a mental health court as soon as June of this year. I would love to be part of a diversionary program such as that, because I think it's important that we help those people with mental illness to get the help that they need to get back on their feet and to avoid being stuck in the system for the long term. We've seen in Bucks County the successes of drug courts, veterans court, and I'm hopeful that if I join the bench that we'll see the same sort of success with the mental health court. I decided to run for the seat because I believe I have the professional experience and the temperament to be a good judge. I believe we should all do what we can to give back to the community. I've done that throughout my career in membership in this bar association. I've served, as I said, on the technology committee. I've served on the board of directors. I've served in other committees in the civil civil law division. I've done that throughout my career outside of the law. I volunteered in my community, in my township, serving on 3 separate boards. I continue to serve my church. I served for 12 years in the Central Bucks School District and had great success in that service. I view being a judge on the Court of Common Pleas as the ultimate community service that a lawyer can do. I believe that I have the broad life and professional experiences that I can share with the judges on our court to make them better and to serve the community in a better way. As I mentioned earlier, Bucks is served by excellent judges who have a reputation for fairness and impartiality. I mentioned my uncle, who I admire. It's my great feeling when I tell my clients, I can't guarantee you the outcome, but I know when we're before Judge X that we're going to have a fair hearing and we're going to get an impartial ruling. And that's the kind of judge I'm going to be. I'm going to be fair and impartial, listen with an open mind, and be decisive in my decision. Thank you for all your time. I appreciate it.
Thanks, Steve. Tiffany, closing.
Thank you. Thank you all for allowing me again to speak with you this evening. This has been such an incredible opportunity for me. It was a new process. Obviously, I've never run for judge before, and we've certainly never done it virtually. So I do, again, want to take the opportunity to thank Frank and thank Chris and thank you, Steve, and thank you, all of the board members, Sean and Greg, for putting this together, because it is an important opportunity, again, for you to see us and to hear from us and to hear what our positions are on different things. First being why we want to be a judge. Secondly, what we would do to be the most effective judge. And third, what kind of results we could bring for you. You're all on this call, and those of you that aren't members of the bar that aren't on the call, to learn more about us. So I hope that this evening has given you an opportunity to learn a little bit more about me, a little bit about my history, and about my practice, and about my family, and why I think that I possess the qualities to be the next best candidate for the judge of Court of Common Pleas. Again, it's because I possess integrity, compassion, commitment to community, and intelligence, and the experience that will broaden the bench. I will bring a certain uniqueness to the bench that is missing, and I think that certain uniqueness will lend itself to different experiences that can be a benefit to the experiences that people are having that come before me, and even to my colleagues, if I'm honored to have colleagues on the bench. So I just want to again thank you all so much for taking your time on this evening, and I hope that you do vote in the plebiscite, and I hope that you do vote and give the highest rating where you think is appropriate. And more importantly, if you're not registered to vote, vote. And if you are registered, consider the mail ballot. And also remember May 18th, and then we'll see you in the general. So thank you.
So now it's my turn to thank you, Tiffany, and to thank you, Steve, for your willingness to participate in this plebiscite. It is, as you both have said, a very important function for the members of the Bar Association, as well as the general community and media, to get the opportunity to see you and hear you respond to the questions that we asked of you this evening. So it is important to all of us, to everybody that has a role to play in this society, that they know who it is that is going to be holding a position of authority, and especially one as a judge, where they are to dispense justice. As both of you have said, the perception of being treated fairly and equally is very, very important, and it's a hallmark of our bench. I'd like to also thank Greg Nardi and our wonderful bar staff for all of the efforts that they have put together and work that they have given of themselves to make this event as easily accessible as it can be under the circumstances that we're all dealing with, given this coronavirus difficulty we all have. So thank you, Greg, and thank you to the staff. I especially would like to thank my co-chair, Chris Brill, who makes every endeavor a pleasant and, quite honestly, a fun adventure. So, Chris, this has been a pleasure serving with you. And I in particular, I'd like to thank the members of the plebiscite committee. We had a fair amount of opportunity to go back and forth with regard to the questions that we asked each of you this evening. So it wasn't the brilliance of Chris and myself. Frankly, it was the brilliance of Darlene Carlton, Elizabeth Feynman, Julie Goldstein, Hillary Mooney, Judith Algio, Georgianne Fusco, and Amy Schnecker. So now, the focus is on you, members of the Bar Association, to participate in this plebiscite by voting. And you all received last week the plebiscite ballot, and some of you may have already voted, but those of you who have not, we would ask you that you do participate by voting. And I would ask that you get your votes into the Bar Association by April the 14th. And your choices with regard to the candidates, Steve and Tiffany, are one of four. That is highly recommended, recommended, not recommended, or no opinion. And lastly, I want to remind you of two important dates. The first is the date for the primary election, which is on May the 18th. And between April 14th and May the 18th, the Bar Association will be publishing the results of our plebiscite. And what all of you have decided is the qualifications of Steve and Tiffany based upon your view of them and their fine responses to the questions that we asked this evening. The second important date is actually the general election, which will occur on November the 2nd this year. So it's important that not only that you go out and vote, but that you get your family members and your friends and your colleagues and the members of your firm to go out and vote, because this is the most important function of a citizen, to get out and vote for the people that are going to have an impact on your life. So, on behalf of the Bar Association, on behalf of the candidates, Chris and myself, thank you very much for participating in this Meet the Candidates evening. I believe, Greg, we are now done.